Hello and welcome to the Mitchell Law Tea Break. I'm Catrin Mitchell and today I'm joined by Catrin Jennet, who's one of our solicitors. Catrin, this is your tea break debut. It's great to get you on the big screen.
Catherine, it's lovely to be here and I'm looking forward to doing more tea breaks in the future. Do you think we should get on with some employment law?
If you like. Today we're going to be discussing a subject that used to be called casual workers or atypical workers, but that's now morphed into the apparently much sexier gig economy. Regular viewers will know that I like to indulge in a little etymology at the beginning, and the use of the term gig for jobbing musicians was apparently first used in 1920s jazz circles.
Wow.
And of course, many of the roles that form the basis of today's gig economy have sadly little to do with showing off your chops on the sax or sipping martinis.
We're talking Uber drivers and Pimlico plumbers, aren't we?
We are, and the big platform companies have been involved in some pretty heavy litigation on the subject. But the fundamental issue here is employment status, and that's been a hot potato for years, for everyone from tiny organisations to huge corporations. And companies using tech platforms to match workers to gigs may be a new thing, but sectors such as social care, cleaning and construction have been reliant on casual labour for decades.
That's right. We've essentially got three classes of people doing work in the UK. At the top level, if you like, are employees who have employment contracts and the full range of statutory rights. In the middle, you've got workers who are not employees but are personally providing services. They have some statutory rights. And at the bottom are the truly self-employed contractors who have essentially no statutory rights and do the work in the course of carrying out business in their own right.
Yeah, and although workers and self-employed contractors have fewer rights, it's not all bad news for them, is it? Because they might benefit from a more lenient tax regime.
That's absolutely right, Catherine. And that's an oddity about the gig economy generally. Roles tend to be clustered at two ends of the job market. Quite low-skilled, low-paid work, where individuals might like to be employed, but haven't got much choice and may potentially face exploitation. Conversely, at the other end, you've got highly paid professionals, often in the areas like IT, who want the flexibility of managing their own tax affairs and working when they want to, who are actively choosing a non-employment model.
And what really doesn't help is that the definitions of employment status for employment law and tax law aren't aligned with each other. So where you have three categories in employment law, you only have two in tax, and there's a different test to determine if someone is self-employed for tax purposes.
Exactly. And say in the 1990s, we probably had more cases about people trying to gain employment rights. For example, to bring unfair dismissal or redundancy claims. But since then, there's been a lot more of new valuable rights which have come into law for the workers, that interim category we were talking about. The gig economy cases are often about people trying to establish now worker status to secure access to those worker rights like paid holiday, national minimum wage, rather than the employee rights.
Yeah, and by and large they've been successful. So we've seen Addison Lee and City Sprint cycle couriers successfully argue that they're workers. We've seen Addison Lee drivers successfully argue they are workers. And we've seen Pimlico plumbers successfully argue that they are workers. But perhaps most widely reported, we've seen Uber drivers succeed in showing that they should be given workers' rights at every level up to the Court of Appeal. Although it's worth being aware that there was a robustly argued dissenting judgment and that permission has been given to take the case to the Supreme Court.
The one major decision which seems to go against the grain was the ruling of the Central Arbitration Committee, upheld by the Court of Appeal, that Deliveroo riders were self-employed contractors and not workers. The key factor there was that the riders were allowed to use a substitute to perform the delivery, provided that the substitute was logged in on the rider's phone and using the same type of vehicle. It's well established in law that a genuine right to substitute is incompatible with worker status, as that status relies on there being an obligation to provide personal service. Crucially, the CAC ruled that it didn't matter if the reason for including the right to substitute was to prevent riders from gaining worker status. provided the right itself was not a sham. There was evidence of it being used, albeit it was on a limited number of riders, and that decision was upheld on the first level of appeal, but we know it might go further.
And on that note, one factor which might come into play in the next generation of employment status cases is the effect of the good old GDPR. And under the GDPR, if you process data and you're not an employee, then you've got various obligations which would not be compatible with a substitute doing your work. And I think looking at the Deliveroo model, allowing a random third party access to the app could involve serious data breaches for both the main rider and potentially Deliveroo itself. So what was a clever argument from an employment law perspective looks potentially much less clever from a GDPR perspective. But that's a conflict we've yet to see play out in the litigation.
Absolutely. And in terms of where we go forward in the immediate future, there seems to be broad agreement that there's a need for more transparency, but very little progress has been made in achieving that. We did have the Taylor reforms published in summer 2017, as viewers might remember, and then the Good Work Plan was announced with some fanfare at the end of last year. However, the reforms set out might reasonably be described as quite small picture stuff, really. There doesn't seem to be any current plan to move away from the tripartite status model, and the difficulty for both employers and employees in working out where they fit into that.
I think that's right. And one related area where things really have been moving, of course, is in relation to the taxation of independent contractors and the changes in the IR35 regime. Now, IR35, some people might remember, started life simply as a press release in 2000, and it was brought in to tackle perceived tax avoidance by contractors offering services through limited companies and paying themselves in dividends. And under IR35, if an individual performs work personally for a client, such that they would otherwise be an employee, but those services are provided through an intermediary, so some type of service company, then income tax and NI are payable essentially as if they were an employee. And lots of contractors took pains to set up their working arrangements so as to stay outside IR35, and their service companies didn't have to pay tax and NI on that basis.
Except from April 2017, public sector organisations engaging contractors have had to determine the status of the contractors they use, rather than leaving it to the intermediary companies themselves. Under this setup, the end user has to account for tax and national insurance through PAYE and face penalties if they get it wrong. They risk significant fines if they wrongly pay someone as an independent contractor, so you can see that there's an incentive to be cautious. Many contractors argue that they have been wrongly labelled as falling within IR35 by overcautious public sector organisations and have had to pay more tax as a result.
Yeah, and the difference can be quite dramatic, can't it?
Absolutely, that's right. Anecdotally, large number of contractors have moved away from accepting public sector work or significantly increased their rates since these changes came in. And the really big news is that it is proposed to roll out similar changes to medium and large-scale private sector organisations from 2020. The contracting sector is obviously fighting against this, arguing that it inhibits flexibility and makes the service they offer unfeasible, particularly those who travel long distances for different assignments and are used to being able to offset travel expenses.
And what do we mean by medium and large organisations?
Well, the proposals are under consultation at the moment, and it's been suggested as a baseline, but it's only a suggestion, that it's about employers with 50 employees or with a turnover of £5 million.
So we'd say that this should be on the agenda of any organisation that uses independent contractors on a regular basis, particularly if you are relying on the same people on an ongoing basis.
Absolutely, it remains one to watch, Catherine. And of course, it's open to employers who may be affected to contribute to the consultation while it remains open. From both an employment rights and a taxation perspective, we have definitely seen a shifting landscape around employment status at the moment, and probably we're going to continue to see it over the next few years. Obviously, we'll be keeping on top of it, and if you'd like any advice as to your own business structure and arrangements, you just have to come and give us a call.
Thank you, Catrin, and thanks to you for watching this tea break, and we look forward to welcoming you again soon.